1, 2, 3. Welcome to the show. Can you?
Grab me a positive synergy. I have been doubted through life. Been there and done that with trifling people who told me my style would not work. I told them they wrong. Been struggling too long. This song is for you. I'm proving you wrong. Get out my way. 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 Get out my way.
Baby, I know you're not used to man keeping their word and following through on what they say. But I want you to know that I'm here for you. And I'm not going nowhere. Come here. Lay your head down on my shoulder. Yeah. Promise you don't have to shed another painful tear. Because I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And I ain't going nowhere. We gon' make it through this thing called life. I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And we gon' ride, we gon' ride. Still remember the day I looked into your eyes. You caught me by surprise. That walk, that talk, the way you made me gravitate towards you. It changed me for the better. You're all I need, and you're all I see. And you're fine as wine. I'm so blessed you're mine. You stole my heart right from the start. When you said hello, I saw your glow. Hey, I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And I ain't going nowhere. We gon' make it through this thing called life. I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And we gon' ride, we gon' ride. Hey, if you ever been in love, put your hands up. If you tired of the lies, put your hands up. Wave them high up to the sky. If you ever been in love, put your hands up. If you tired of the lies, put your hands up. Wave them high up to the sky. I'm your man, yeah, I'm your man, I'm your man. And I ain't going nowhere. We gon' make it through this thing called life. I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And we gon' ride, we gon' ride. I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And I ain't going nowhere. We gon' make it through this thing called life. I'm your man, I'm your man, I'm your man, I'm your man, I'm your man. And we gon' ride, we gon' ride. Lay your head down on my shoulder. Yeah, yeah.
We back, y'all. We back. I told y'all I'd be back. I try to be on time. Let me see who back with us. Davis Campos, what up? How are you? Frankie and Johnny Golden Doodles, how are you? Miss Frankie said, good evening, everyone coming into the chat. Hit the like button, please, and thank you. Let me see who else up in here. Mary Ann, what up, Mary Ann? That's your jam. I'm happy you like that song. What's up, Jenny Smith? How are you? Thanks for coming in. Appreciate you. Thank you. Let me see. Yes, we back, Miss Cherie Harris. We back. Faith Beerish, you back. Welcome back. Okay, y'all. So there were some things that I found looking around through this Diddy stuff that I wanted to kind of make sure that we don't miss stuff. Like, the thing about it is, if we stay on top of this, we won't miss much, right? So if we have these lives, we have them recorded, we can always go back to them and say, hey, do you remember this said this? Because as this thing gets deeper and it goes on, there's going to be things that we're going to be like, hold on, they did say that. Where we finally read it back here, we can go back to it, okay? So what's up to be Black Native? Welcome back. All right, so this is what I wanted to show y'all. This was something dealing with the discovery, I believe. Let me pull this up and share my screen so y'all can see what I am talking about. Let's see, is it the first one? Nope, right here. Let me see what this is. Okay, so let me make sure y'all can see this. Let me blow this up. Here we go. So y'all, this was actually put out yesterday also. This is, let me open this up so y'all can see full screen. There we go. So this right here is a document to the judge where it's actually, this is to the judge where it's talking about, let's see here. Let me read it. It says to the Honorable Arun Sabaramian. I'm going to have to really learn that name, y'all. It says, Dear Judge, the parties respectfully submit this joint letter in response to the court's order dated October 4th, 2024, directing the parties to outline the issues the parties believe should be addressed at the pretrial conference scheduled to proceed on October 10th, 2024. So that is what happened today, okay? That's what happened today on the 10th. As we know, there were some things that were brought up, and P. Diddy was denied bail again. This is his third time, I believe, being denied by 3 different judges. Now, y'all got to understand that this is not the typical slap on the wrist type stuff. It was 3 separate. What's up, Tiffany Pennick? How are you? There's 3 separate judges that, no, you stand your tail in jail. You ain't getting out, right? So let's read this, y'all. So the first thing they talked about was the discovery. So this is the government's position. This is the government's position, y'all, okay? So they presented this as a joint letter. So this is going to be a very interesting thing that we're going to read, because a lot of the evidence that we talk about as far as discovery is going to probably be right here in at least giving you an indication of what they are looking at and what they have found. Okay, so let's go ahead and get into this. Give me a minute. Hold on, y'all. No. In the field. The field. Today. All right, here we go. So, let's read this. Discovery. In this case is voluminous. So that means it is a lot of discovery that the government says they have, totaling several terabytes of electronic material, okay? And consists primarily of the following categories. A, electronically stored information belonging to the defendant, cell phones, laptops, tablets, hard drives, cloud accounts, etc. B, electronically stored information of third parties, cell phones, laptops, tablets, and cloud accounts. I believe that would be other people's stuff, okay, that they found that was either in his house or came from other people. C, business records from financial institutions, phone companies, hotels, airlines, and other businesses. D, physical evidence seized in searches of the defendant's residence. E, law enforcement records set forth herein. The government will be prepared to answer any questions from the court at the upcoming conference regarding the status and contents of discovery, including the various types of discovery, the status and anticipated timeline of extracting electronically stored information, and the anticipated time needed to produce the remaining discovery in the government's possession. So they're saying they got a lot of stuff, y'all, okay? It says here that the government has been in close coordination with the defense regarding the production of discovery in this case. The government has prioritized the expedient production of the defendant's electronically stored information, which makes up a significant portion of the total discovery in the case. Since the defendant's arrest on September 16th, 2024, the parties have engaged in extensive negotiations regarding the protective order, which the court signed on October 4th, 2024, and docketed on October 7th of 2024. On September 25th, 2024, the government requests hard drives from the defense for discovery, which it received on October 1st, 2024. On October 7th, 2024, the government made his first production of discovery, which included, among other things, a complete set of search warrants in the case, iCloud reports for the two defendants' accounts, and iCloud reports for two defendants' accounts. Okay, two defendants' accounts. Okay. And the defendant's phone seized on March 25th, 2024, which defense counsel specifically requested be produced in the first production. The following days, and as related to the defense, the government began copying over 47 and the other 5 iCloud reports belonging to the defendant, which is expected to take several days due to the volume of the materials. Y'all, they probably got so many videos, so much stuff. They say they got terabytes of stuff, y'all, that they got to look through. God only knows how many years has he been doing this. How many years has he been doing this? Can y'all imagine how many videos that they have? Lasting impressions by Kim. What's up? How are you? Thanks for coming in. May 1994. Thanks for coming back. Can y'all imagine how much stuff they really have on Diddy? Like, can you really imagine? It's going to take 7 days for them to comb through this stuff. All right. Let's get back. So it says, the following the iCloud reports belonging to the defendant, which is expected to take several days due to the volume of the materials. The government also informed the defense that in addition to those devices and iCloud accounts, it expected to make rolling productions within the next 30 days of hard drives that were seized from the defendant. The subpoena returns currently in the government's possession and materials from the searches executed at the defendant's residence and hotel room. To the extent that the defense position below suggests otherwise, the government wishes to clarify that it has been endeavoring to extract devices seized from the defendant as expediently as possible since their seizure, without responsiveness or privileged reviews. Finally, the government informed the defense that it expected to produce the remainder of discovery, including electronic information seized from devices and cloud accounts belonging to other individuals on a rolling basis by the end of the year. It says that the electronically stored information from the third parties must be reviewed before it can be produced to the defendant, and in many cases must first be reviewed for privilege. The government's investigation is ongoing, and it will continue to review and produce discovery on a rolling basis as it receives Rule 16 material or as technology advancements allow the government to access electronically stored information that has not yet been extracted. Okay, so that was the government's position. From what the judge said, I need you to tell me what y'all want to talk about on the 10th, which was today. Okay. Now we're going to see what the defense, what is Sean Combs' lawyer saying that they want to talk about. Here we go. The parties are in almost daily discussions concerning discovery. The defense intends to ask the court to require the government to immediately produce certain categories of information, namely copies of Mr. Combs' electronic devices that were seized over 6 months ago and at the time of his arrest, and certain categories of requested Brady material, and to timely review and produce the remaining Rule 16 material in their possession. Outstanding subpoena returns and electronic stored information belonging to other individuals, many of which also have been in government's possession for many months. It says here, through our dialogue with the government, we understand that the government seized a significant amount of Mr. Combs' electronic devices and data pursuant to search warrants that were executed on March 25th, 2024. The government also seized additional devices belonging to Mr. Combs at the time of his arrest about 3 weeks ago. We also understand that the government is only now beginning to review and copy these electronic devices, including those that were seized in March 2024. The timely production of these materials is critical to Mr. Combs' ability to prepare his defense. And because these devices belong to Mr. Combs, their production should not be delayed by the government's initial review for responsiveness and privilege. The government has indicated that they will be able to produce these devices in the next 30 days. With respect to our categories of Rule 16 material, we intend to ask the court to set a reasonable production deadline to allow for sufficient time to review the material in advance to a spring trial date. Trial and motion scheduling. The defense's position is that Mr. Combs continues to assert his right to a speedy trial and intends to request a trial date in April or May of 2025. See, y'all, so I'm glad we read this, because we read earlier when they had a typo in that paperwork where they said in 2024. But we can see here that obviously that was a typo. And it says, and as consistent as the court's trial schedule. Mr. Combs also seeks deadlines for filing of pretrial motions with permission to raise certain pretrial motions in advance of any deadline. For example, at some point today, Mr. Combs intends to file a motion for a hearing and other remedies related to unauthorized and presidential leaks of the grand jury information. The government's position is the government will be available for trial on the date set by the court, although it remains within the court's discretion to set a trial date at the outset of the case or at a later time. Respectfully submitted, Damian Williams, who is the U.S. attorney. And so that's what that is, y'all. So y'all can very clearly see that a lot of information has been collected against Sean Diddy Combs. They have a lot of video stuff. They got terabytes of stuff. Like, this is really going to be crazy, really overwhelming. Okay. So now let's get back to what we were reading earlier. Let me take this down and let me pull this back up. Thank you all so much for coming back. I appreciate you. All right, here we go. All right, y'all. So we had actually stopped at, let's see, right here in the middle of page 7. So here we go. We're going to pick up where we left off, okay? So I'm going to go up a little bit just so y'all can see where we came in. So this is at the top of page 10 of 17. So describe video evidence obtained during the investigation. This client or this agent went on to tell the press, so if you were in those sex parties, you were being recorded from every possible angle, including angles you wouldn't have known about. The Homeland Security agent then told New York Post, in my opinion, he's as bad as Jeffrey Epstein. I mean, these women were young, either barely legal or barely illegal. Y'all, this is crazy. So they're pretty much saying that they have seen evidence of him being with or dealing with or having very young girls that were either barely legal or barely illegal. That's crazy. It says for the government employee to make statements to a New York Post reporter are false, damaging, and prejudicial. It says that the indictment alleges a single victim as part of sex trafficking charge. An adult woman with whom Mr. Combs had a romantic relationship with for 10 years, for the agent to make public statements that the conduct involves barely legal women and that Combs is as bad as Jeffrey Epstein is destructive to Mr. Combs' right to a fair trial. Particularly, I see what they're trying to say, because somebody put that out there publicly that's going to taint the juries. I get what they're trying to say. Particularly in light of the fact that the only victim in the indictment was an adult throughout the charged conduct. Taken together, the false prejudicial statements and leaks serve to feed further sensationalistic media coverage and prejudice potential jurors in advance of trial. Number 3, now they're going to talk about the leaked videotape, y'all. In the midst of his 7-month campaign to impugn Mr. Combs' reputation before trial, on Friday, May 17, 2024, a 2016 videotape from the Intercontinental Hotel in Los Angeles was leaked to CNN. By far, the most likely source of a leak is the government. That is true for several reasons. First, as set forth above, or by May 17, 2024, federal agents had already engaged in a months-long campaign of leaking information to the press. They had a demonstrated propensity of embracing contacts at numerous press outlets and leaking information in order to produce media coverage. It says here, second, victim number 1 is not a likely source of the leak. There is no evidence that either she or her lawyers had possession of the tape. To the contrary, had either victim 1 or her lawyer had the tape, the allegation in a civil complaint would have been entirely different, as far more specific than they were. Moreover, victim number 1 had no motive to approach law enforcement, much less to leak a videotape. She had sued Mr. Combs and received a substantial 8-figure settlement. Remember we was wondering how much he had paid her? Well, they trying to say that he paid her 8 figures, y'all. He wanted to get rid of that, okay? The government's investigation only began after her lawsuit was settled. Third, now, I was saying that when he settled that thing so quick, it's going to make him look guilty. And obviously he was. Third, an unrelated third party is not a likely source. If a person not in law enforcement were to leak the videotape to a news source, that person likely would have sold the tape rather than simply gave it to CNN. Outlets such as TMZ are known to pay tens of thousands of dollars for such footage. That was leaked instead to CNN showed a motive other than financial profit. It showed a motive to damage Mr. Combs' reputation without remuneration, a motive held by federal agents. Fourth, the timing of the leak suggests government involvement. The tape was leaked on one of the few days the Trump trial was not being held, as Barron Trump, Donald Trump's youngest son, graduated that day from high school in Florida with his father in attendance. One of the more contentious issues in the Trump trial was whether trial would be staged so Trump could attend his son's graduation. Eventually, the court announced on May 17th would not be a trial day. This was the fact that would have been known to federal agents, and they also would have known that May 17th was thus a perfect time, and as a slow news day given the break in the Trump trial. Early in the morning on May 17th, a CNN reporter informed a member of Mr. Combs' public relations team that CNN has come across a video from the International Hotel. The reporter went on to say, through our reporting, we have confirmed this video is authentic. The reporter sought comment and also stated that CNN was reaching out to victim number one's representatives for comment. At 10:22 a.m. that morning, the defense counsel emailed the prosecution team to say that CNN was in possession of this videotape and that counsel was concerned about the circumstances in which it was provided to CNN. The government acknowledged defense counsel's email hours after the tape was made public, but as far as defense counsel is aware, took no further action. Regardless of the few hours after defense counsel made the prosecutors aware that CNN had the tape, CNN released it to an overwhelming international attention. The videotape was leaked to CNN, and one reason alone was to mortally wound the reputation and the prospect of Sean Combs successfully defending himself against these allegations. Rather than using the videotape as trial evidence alongside other evidence that gives it context and meaning, the agents misused it in the most prejudicial and damaging way possible. The government knew what it had, a frankly deplorable video recorded of Sean Combs in a towel, hitting, kicking, and dragging a woman in full view of the camera in the hallway of the Now, see, honestly, I'm going to be honest with y'all. If I was his lawyer, the last thing I would want to do is remind people about that videotape. I don't want to talk about that videotape. We've already settled that with that girl. That's already been done. Why are we talking about it? Why do you want to remind people about what they saw? It was horrific. It was horrific what he did to that girl. Horrific. But the fact that his lawyers want to bring it back up to try to use it and have people like me read it and bring it back up, all it does is rekindle the reason why we think he should be locked up underneath the jail for the rest of his life. Okay? It says here, the potential problem for the government is that if an agent provided this videotape to CNN, this will be a violation of the grand jury secrecy. This is, among other things, what the hearing will determine, because it is reasonable to believe that this was obtained in connection with the grand jury investigation, that it was intentionally given to CNN to be released to the world, and that there is a strong possibility that the person providing it to CNN was a federal agent involved in this grand jury investigation. The remedy for this conduct should be full suppression of the videotape that the government leaked. Let me tell you something. That video will not be suppressed. Oh no. The government gonna make sure that thing is played over and over and over again. Here's a footnote, y'all. It says, after the undersigned notified the government that we would be filing this motion, prosecutors responded to the video broadcast by CNN was not obtained through grand jury process, and that DHS did not have possession of the videotape prior to CNN's publication of it. However, government attorneys have not given any indication that they have investigated any of the leaks related to the case. And as discussed, we are not suggesting that the U.S. Attorney's Office itself leaked the videotape, but given all the evidence cited above and the sheer number of agents. C, the court's authority. This court has the authority to investigate the government's actions and to order appropriate remedies. Its authority begins with Federal Rule of Criminal Procedure 6, which mandates secrecy of grand jury proceedings and materials. A violation Rule 6E occurs when a covered person discloses anything that will reveal what transpired during the grand jury proceedings. In Re-Grand Jury Subpoena 103, it says covered persons include attorneys for the government and other government personnel assisting government attorneys. It says both direct and indirect disclosure of information are proscribed. Secrecy extends not just to the grand jury transcripts, but also to all materials related to or affecting the grand jury. There's more case law here. It says confidently provisions to cover matters beyond those actually occurring before the grand jury. Federal courts are obligated to enforce the rule by imposing sanctions on those who violate in secrecy provisions. Rule 6 itself states that a violation of that secrecy may be punished as a contempt of court. More case law says that this is not the sole possible remedy. It says dismissal or other possible remedies and suppression of grand jury material, or in extraordinary cases, dismissal of an indictment. Oh wow, they're trying to say because that was leaked out that they want a dismissal of the indictment. Not gonna happen. Indeed, Rule 6 indicates no limits on the self-relief available to address violations. Here's some more footnotes involved in the investigation and history of leaks. It seems entirely reasonable that the video was leaked by one or more DHS agents. It says here, more generally, this court has inherent authority under its supervisory powers to address this sort of misconduct. Federal courts may exercise their supervisory powers to prevent parties from reaping benefit or incurring harm from violations of substantive or procedural rules imposed by the constitutional laws. Here's some case law, United States versus Williams, where the government misconduct includes actions whereby the government seeks to obtain an unfair advantage long before the trial has begun. United States versus Stein. It says to defer and punish such misconduct, the court has the authority to formulate procedural rules that apply to officers of the court, including all members of the bar and the United States attorneys. Pretrial statements to the press that have the tendency to prejudice a criminal defendant's right to a fair trial are prohibited by Rule 3 of the New York Rules of Professional Conduct and the Southern District of New York Local Criminal Rule 23-1. Additionally, federal regulations bar all Department of Justice employees, not just the attorneys, from making prejudicial information prior to trial. The release of information for the purpose of influencing a trial is, of course, always improper. It says, at no time shall personnel of the defendant of the Department of Justice furnish any statement or information for the purpose of influencing the outcome of a defendant's trial, nor shall personnel of the defendant furnish any statement or information which could reasonably be expected to be disseminated by means of public communication. If such a statement or information may reasonably be expected to influence the outcome of a pending or future trial. These provisions specifically note that observations about a defendant's character, statements concerning the credibility of prospective witnesses, and opinion of the accused's guilt are never permissible, especially and the period leading up to the trial. So, y'all, what they're trying to do is they're trying to throw a haymaker and say, hey, we need to just go ahead and just get rid of all of this stuff, get rid of the video. It's already been tainted. The jury already seen it. That's probably why they indicted him. And so this case should just pretty much be dismissed and thrown out. That's what they're trying to do. Okay, that's their job. Now, through corrupt attempt to influence the grand jury and petty jurors, this court has the authority to craft rules and remedies to enforce those provisions which have been violated by federal agents in this case. This court also has the authority and indeed the duty to investigate government misconduct. Most often, conducting a hearing is the preferred course of action in cases where disputed factual issues exist. They cite more case law, United States versus Covello. It says here that once a prima facie a showing of misconduct has been made, court should conduct an evidentiary hearing. They got more case law here. It says, moreover, this court has the authority to impose a gag order, that is an order prohibiting extrajudicial statements by any lawyer, party, witness, or court official which divulged prejudicial matters. Shepard versus Maxwell, they cite more case law. Court have an ongoing obligation to ensure that speech about a criminal case does not prejudice the proceedings. They more case law. United States versus Trump. Look at them. And while the court may have only limited authority to limit the speech of the press, they have much broader authority to police attorneys and other trial participants. Now, finally, once the court has ascertained the full extent of misconduct, it has wide latitude to fashion an appropriate remedy. Rule 6 indicates that no limits of the relief available to address violations. More case law has been violated. The sanctions that must be imposed include imprisonment or criminal contempt and dismissal of the case. That's what they want, y'all. That's really what they want. They want dismissal of the case. Other possible remedies include suppression of grand jury material. They cite more case law, where they say the defendants reserve the right to seek one or more of these remedies, including suppression of the videotape following the evidentiary hearing. Listen, y'all, they keep trying to go for this videotape. That thing is already out there. That thing has been replayed. replayed. It's not going nowhere. Requested relief. Based on the foregoing, Mr. Combs requests the following relief. First, this court should order an evidentiary hearing to investigate the misconduct detailed above, as well as other misconduct that may yet come to light. Here, the defense has made a prima facie showing that a hearing should be held because it is clear agents involved in this investigation spoke to the press about matters related to or affecting the grand jury and leaked evidence. The agents here were specifically identified in press accounts as HSI officers and DHS operatives, and specifically an Miami-based officer who helped raid Mr. Combs' Florida abode. These officers disclosed specific information about the investigation, including its target, the types of search warrants obtained, and material sought. What witnesses had reported to prosecutors and actual evidence reveal the nature or direction of a grand jury proceeding. It says, second, in advance to the hearing, the court should order relevant discovery from the government. This should include any emails and text messages by any government attorneys or law enforcement agents regarding these and any other leaks of information about the investigation or prosecution of the case. Third, this court should immediately enter an order forbidding government attorneys and others involved in the case from leaking any further information to the media. This order should cover all grand jury material as well as other non-public information related to the investigation and prosecution of this case. Fourth, after the evidentiary hearing and the extent and nature of the misconduct has been clarified, Mr. Combs will submit requests for any additional appropriate remedies, including disqualification of witnesses, suppression of evidence, including the 2016 video, or dismissal of all charges in the indictment. Respectfully submitted, P. Diddy's lawyer. Y'all, I'm going to open up the channel for anybody that wants to come in and speak your mind. Let me go ahead and post the link here for you. I'm going to put it in the chat. Y'all, this is crazy. Let me copy this, come over here, and I'm going to paste it. There you go. Anybody that wants to come on the channel to talk, come on. Come on, express yourself. Let me hear what you think about this. If you think you know that Diddy didn't do it, let's talk about it. If you think that all they're trying to do is just trying to cover this thing up, let's talk about it. Okay? Until somebody call in, I'm going to read through some of y'all's messages here. Let's see. Cherie Harris says, get all that damn money and can't even bond. Got all that damn money, can't even bond out of jail. My broke ass can bond out of jail before Diddy can. LOL. Now that's a damn shame. Yeah. Sometimes with these charges, though, 7. I was about to ask, was there an ETA to see what's there? Yep. All that money won't spend it. Yep. Did you hit the like button? Okay. Why he like to drag everybody though? Atlas, I love your new intro. I love your new song. Very nice. Thank you, Hayward Janelle. I appreciate it. Thank you so much. What's up, Natalia Singh? How are you? Long time no see. Charlotte McAdams, howdy. How are you? Angela Duncan, hello. How are you? All right. Let me see if y'all got it. Lesmond 1, what's up? How are you? Thanks for coming in. Appreciate you. Let's see. Who else? Let me see some other messages here. Miss Lesmond 1 said, here's the thing. How did the agent get it? Possibly from his house, if the defense's theory is correct. So I must ask, what kind of sick individual keeps something like that? Right. Absolutely, Lesson 1. Who would want to keep something like that? Who would want to keep something like that around? Like something you want to sit back and watch later? That's a great question. They must be smoking. Yeah, got to be. If this is your first time watching here, Dripper had there you go. What's going on? Toya Lambert, how are you? Hi, I love that you keep us informed. Indeed. Oh yeah, y'all. We're gonna dig into this. Welcome, Toya. I almost never catch it live. Well, I'm glad you did today. That's awesome. Let's see. Lesson 1 said he wants that video gone. Why? Because it shows the nature of his character, predator, period. Listen, there's nothing more that he wants gone than that video. Okay, why he was drugging them people though? Because he crazy. He crazy. What's up, Diva Time? What's going on? Man, y'all, I'm gonna just be real with y'all. This whole thing is you never know who people are. You know, you see interviews on them, you listen to their music, you think that song when he wrote that one with about Big, every breath I take, every move I make. That song, you would think that he was really genuine about that. Now they're trying to say that he was a part of the reason why Big got killed. All because he was jealous because Biggie wrote music for Lil' Kim and them. Like, this is crazy, y'all. This is crazy. I mean, they're trying to say he's linked to Biggie's passing. They're trying to say that he's linked to Tupac's unaliving. Like, this is really crazy that this man has just been doing this and getting away with this. And, you know, allegedly he shot some girl in the face. I mean, it's crazy. Allegedly he beat some football coach up with a dumbbell, beat him all in the head, almost killed the man. Like, this man needs to be stopped, literally stopped, right? But y'all listen, enterprise, there you go. They definitely have an enterprise. And I believe the more that we dig into this, y'all, the more we're going to discover. I am now linked in to where I could just go in and figure out whatever's released. I could just come on and read it for y'all. So we're going to be on top of it. We're going to definitely be on top of it. But I want y'all to know that I appreciate y'all for coming over here. It's good to be back in here doing what I love to do, which is bring y'all this information. We are one of the most genuine channels on YouTube, if you ask me, when it comes to bringing the information to you without no bias. We just keeping it real. Okay. Davis Campos says, where are his friends? I don't think he got too many people that's going to come to his aid other than what? Boosie. Well, Boosie come to everybody aid who's a pedophile or dealing with kids and everything. Because you never know what he doing behind the scenes. You never know. So it's kind of crazy. You know, sometimes birds of a feather flock together. He may be on some videos himself doing stuff. So he's trying to say, hey, man, I'm out here protecting you. Don't put nothing out about me. But you never know what the government got. You never know. And I think it's going to be very interesting to know what in that discovery phase. Now, I did hear something the other day where there were a lot of celebrities starting to pay Diddy to not expose them. I don't know how true that is, if that's just, you know, whatever, propaganda, whatever. But they say that a lot of celebrities have been paying him to keep his mouth shut. So I don't know. But y'all, listen, I appreciate y'all. Thank y'all so much. If y'all could all 30 of y'all can hit that like button just to show your bro some love. I would appreciate it. Okay. Ms. Lambert said, I have a feeling it's something in the baby oil bottles. You might be on to something. You may be on to something. He might have laced the baby oil, y'all. Wouldn't that be crazy if he found a way to lace the baby oil? That's crazy. Something to think about. But y'all, listen. I will post next time I'll be back on here to read more stuff come out. We're going to stay on top of it, okay? I love y'all. I appreciate y'all. Thank y'all for coming up over here. And I will holler at y'all later on. Hit the like button on the way out. Peace out.
Haters, all good. Thought I couldn't when I could. Had a